Now back to the show. This is The Law Show on CL 650.
I'm Zach Spencer. Welcome back to the show. And today we're talking about something that's very important. We joked a little bit about it before, the two certainties in life, death and taxes. And we actually touched on both there in the previous segment. But, we're talking about wills and estate law and why it's so important. You've got to get it right or else things can go sideways after you pass on. And this is your last letter to the world when you leave. And John Lakes and John White are here to give us expert advice. They have a law firm in North Vancouver, LakesWhyteLLP, to talk about what you should do. And we've gone through all of the things already: executors, trustees, gift clauses, and now we're getting down to the money, gifts and funds. So, John, what do you do with the next set?
Well, let's say we've got an imaginary estate. We're down to about $500,000. Everything's paid off. So, you may want to give some gifts to people that are friends or charities or so forth, but you don't want to give too much away. But let's say you're going to give $50,000 to various things, and you want to leave $10,000 to Liam Larson. However, there's both a father and a son who's Liam Larson, so you want to say it's my son, my brother Liam Larson. So whoever you leave money to, you need to give certainty.
Is the middle name important? I guess that would
well,
be easier.
Sometimes it is, and the last address you may have, or last email address, because if not, if you haven't made it certain, then the executor is going to have to hire a skip tracer to find the person, or John may have to go to court to say, who is this money really to go to? So it's really important to identify who's to receive the funds and what happens if they die before you. And it's even more so with issues with charities, which John's going to talk about now.
Well, I mean, there's the problem with giving money to charities. Firstly, giving money to charities in your will is a great idea. Charities love it. They rely on that money, and I wouldn't ever want to discourage anybody from giving money to a charity in their will. But if you're going to do that, name the charity properly so that there's no doubt as to what your intention was as to who is going to get the money. Mm-hmm. And sometimes you see, for example, wills that say, well, I want to give $10,000 to fight cancer in British Columbia. Well,
who gets that? Yeah.
That's not very helpful. That's not very precise.
Is it the Cancer Society? It's the Cancer Agency, and that's where the trickiness comes in,
You
right?
can find all sorts of agencies who could argue that they fight cancer. You want to be more specific than that. If you're not, then there's room for the court to sort out the disputes. The executor absolutely shouldn't make his or her best guess and hope that they've got the right party, because if they got the wrong party, they could be personally liable for the amount of that gift. But you'd have to go to court for that.
Could you give us a quick example about how it could be slightly different?
Well, I mean, there's a famous case out of England. It's one of my favorite cases in this area, where there was a will that made a bequest to something called the Wesleyan Methodist Superannuated Ministers Fund.
It's a mouthful.
It sounds terribly precise if someone had an idea of exactly what they wanted to do. The problem was there was no such thing as the Wesleyan Methodist Superannuated Ministers Fund. But in this case, the court was satisfied that there was something out there called the Connectional Society of the Wesleyan Methodist Church. That's a good start. And that this society maintained a fund called the Superannuated or Worn Out Preachers Fund. And the court put two and two together and was satisfied that the Superannuated or Worn Out Preachers Fund of the Connectional Society of the Wesleyan Methodist Church was probably what the testator had in mind when he left money to the Wesleyan Methodist Superannuated Ministers Fund. In that case, the court was able to figure out what the intention of the testator, or the will maker, as we call them now.
Well, that one's pretty obvious because there's no things that sound like that.
Well, you wouldn't think so.
Yeah, so that's easier. But when you get into things that, as you mentioned, two people have the same name, or they kind of get the name of the cancer agency right, then you're tricky, right?
But it makes it easier now because every charity has their own web page, so you can go on and get their legal information, including their full name, address, and also CRA's got a website as well. So. So the whole point, going back to the theme, is the will has to have certainty. Now, the other thing that's concerned is whether a gift is contrary due to public policy. It used to be sometimes people would put in wills that if someone didn't marry, they wouldn't get the money, or else they didn't belong the right religion or anything. And then, of course, in Canada, we had the very famous case that John will talk to about the stork race. So, John.
Well, just the stork derby, as it was called. There was a guy in Toronto who was a bit of a practical joker, and he left a sum of money in the 1920s, basically to the families that could produce the most children in the next 10 years. And so the birth rate in Toronto went up a little bit, and it, of course, became a big fight for various reasons. And one, I think, would question today whether a provision like that really is in accordance with sound public policy today.
Was the money awarded? Was it?
Oh, they awarded it in the end. They awarded the money. They settled the lawsuits. It all got resolved at the end of the day. But I'll bet you that more money was spent in court than was the subject of this particular bequest. I guess this guy wanted to cause trouble, this will maker, and he certainly succeeded in doing that. But there's a situation where his intent was really clear, but the gift was, I think we could say today, was pretty unwise and a little bit of troublemaking.
Yeah. So is there kind of an example you can use today where it wouldn't be looked at favorably?
Well, I mean, I think if somebody said in their will, I disinherit my daughter if she is a lesbian, or I disinherit my daughter because she marries a Muslim person, I think the courts would not accept that now. Mm-hmm. We don't have those terms anymore of illegitimacy, children, or bastards, or any of those terms anymore. But I think the court has the right to intervene if they think these things are. I mean, first of all, they respect the executor can make certain decisions, but however, if they feel that it's void for public policy, that they do not think this is a reason for people to be disinherited, then there's always a risk. So if you want to do something controversial in your will, it may not stand.
So in the last 2 minutes we have here, what do you have to say to somebody who's tuned in today and is thinking about their will, or maybe they hadn't thought of their will in a while and now they're rethinking it because they've heard this show? What do you say to that person? What do you need to get right?
Well, be clear as to what your intentions are. First and foremost, that is what the court is going to want to do if you don't get it right. So you might as well get it right the first time and avoid having to take the case to court altogether. So be clear as to what your intentions are. Communicate those intentions clearly to the person drawing up your will, and ensure that before you sign your will, those intentions are, so far as you can tell, stated clearly in the will.
And it's not too onerous a cost, right, John? It's
not.
What's the average?
Yeah, maybe 500 to 1,000, but that's less than half a day's court time. Mm-hmm. I mean, I think that people have got a lot of assets. They've worked hard to accumulate what they have, and you don't fill in your own teeth fillings on yourself. You go to a dentist.
Yeah, hopefully. Go
to a lawyer, or if it's relatively simple, go to a notary, but have it done properly, because they're professionals, they're objective, they've done it. Most of them have wills that have been successful, and they can sometimes steer you in a way that you may not realize until you've dealt with a professional.
John Lakes and John White have been my guests today on The Law Show here on CL 650, LakesWhyteLLP in North Vancouver. Thanks, gentlemen, for coming in, and we'll speak to you again right here on CL 650.